Welcome to AutoNoFaultLaw.com and the Utilization Review page. My name is Katie Tucker. I'm an attorney at the Lansing office of the Sinas Dramis Law Firm, and I'm here with you to share some information, basic information and a general overview of the new Diffs Utilization Review rules. So let's get started. I'm going to share my screen with all of you and a brief PowerPoint presentation and some of the basics that you need to know to understand the new utilization review process and the rules. So beginning with a 10,000 foot view, what is utilization review? It's the initial evaluation by an insurer or the MCCA of the appropriateness in terms of both the level and the quality of treatment, products, services, or accommodations under the statute based on medically accepted standards. And this definition comes from the statute itself, from section 3157A sub 6. What does utilization review apply to? Well, it does apply to allowable expense benefits, or what are commonly referred to as medical expenses under the no-fault law, specifically under section 31071A. Things like bills for doctor's appointments, physical therapy, occupational therapy, other skilled therapy, skilled nursing, as well as things like attendant care, transportation services, and the list goes on. It does not, importantly, apply to work loss benefits, which are set forth under section 31071B of the no-fault law. And it also does not apply to replacement services, which are commonly thought of as domestic household chores, things like washing dishes, laundry, sweeping, and other sort of general household or yard work chores or maintenance items. So attendant care and other allowable expenses are covered by utilization review. Work loss and replacement services are not. Recall just a moment ago that the statute defines utilization review as the determination or the evaluation based on medically accepted standards as to whether care is appropriate and whether the cost of that care is appropriate. So what are these medically accepted standards? Well, the statute actually does not define medically accepted standards, that term of art, but the rules, the Diffs Utilization Review rules do. And the rules define medically accepted standards, as you see on your screen, the most appropriate practice guidelines for the treatment, training, product, services, or accommodations provided to an injured person. Guidelines which may include generally accepted practice guidelines, evidence-based practice guidelines, or any other practice guidelines developed by the federal government or national or professional medical societies, boards, associations. So as you can see, it's a broad, expansive definition, but the rules do give us some guidance about what constitute medically accepted standards. What governs utilization review? Utilization review is actually governed by a set of rules that were developed and drafted and promulgated by the Department of Insurance and Financial Services, the Diffs Rules. I'm sharing with you here the first page of those rules. There are 9 in total, and these rules were adopted and became effective, as you can see in the first page of the rules themselves, on December 18, 2020. So utilization review, as contemplated by the Michigan no-fault law, is actually governed by this separate set of rules that were promulgated by Diffs. Why did Diffs promulgate this separate set of rules to address utilization review? Well, it was expressly authorized and obligated to do so by our Michigan legislature in section 3157A of the no-fault statute. And as part of that statutory provision, Diffs also outlined exactly what utilization review rules can and should address and include. Who is affected by the utilization review rules? Who is involved in the utilization review process? Who is subject to utilization review? Well, the Michigan Department of Insurance and Financial Services, Diffs, as I just mentioned, is responsible for promulgating the rules. The Joint Committee on Administrative Rules, which is a legislative committee comprised of 5 members of our state House and 5 members of our state Senate, was responsible for reviewing the proposed rules and adopting them. Under the rules, which are now effective, the individual vested with authority to make decisions is the Diffs director, who is currently Anita Fox. And the rules define who is affected by them as insurers, the Michigan Catastrophic Claims Association, and providers. And provider, that term of art again, is defined by the rules as a physician, hospital, clinic, or other person providing treatment, training, product, services, or accommodations to an injured person. So as you can see, it's a broad, expansive definition, and certainly I think broad enough to encompass and include providers of case management services, guardianship services, transportation services, and other ancillary services. So I think the definition of provider set forth under the Diffs rules is broad enough to include individuals who provide services to auto accident victims, even if they are not actually providing medical care. So this is really important and significant. And most individuals providing any sort of a service or treatment to auto accident victims in Michigan are going to be subject to and governed by these new rules. When do the rules apply? When do they take effect? Well, the rules actually apply to treatment rendered after July 1st of 2020. As you can see, that's plain from the language of the rules themselves, Rule 62(1)(c), and also from the statutory provision that gives rise to the rule, Section 3157A. And notably, however, the rules themselves did not become effective until the legislature officially adopted them on December 18th, 2020. So take note of the fact that the rules can and will be applied to treatment provided after July 1st, 2020, but the rules themselves actually became effective several months later on December 18th of 2020. With that, I will encourage you to learn more about the utilization review rules from our site, from ANFL. You can check out another presentation on the utilization review process and frequently asked questions and answers. I hope that this basic information and overview has been helpful to you, and please do not hesitate to reach out to our editorial board if you do have questions or would like to see other content on these rules as part of the ANFL site. Thank you.